welcome to the deep dive. Sometimes the most explosive stories in the legal world are kind of hidden behind these really dry titles. Today, we're taking a deep breath and diving into what looks like a mundane court ruling, just a motion to change a legal document. But it actually opens up some, well, breathtaking allegations. We're talking about fraud, coordinated injury claims, potential deceit, all involving Columbia University. Our mission today is really to shortcut your understanding of this key legal moment. We're zeroing in on our November 2025 decision. It's from the New York Appellate Division, First Department, in Taveras v. Tuck-It-Away Associates, LP. And we really need to figure out what specific facts, what evidence convinced a high court to say, yes, the defendant can accuse the plaintiff of fraud.
Yeah, and this is such a valuable case, I think, for anyone interested in legal strategy. It really lays out the bar you need to clear if you want to, well, accuse someone of lying in court. It's not just about having a hunch, right? Columbia had to show real specific evidence. And the court found these allegations were compelling enough to move forward. They said they were not clearly devoid of merit.
Which is legal speak for. It basically means, look, there's enough substance here. This isn't frivolous. It deserves a proper hearing.
Oh, okay, right. So let's unpack the starting point. Columbia University, they're the defendant here. They decided mid-case, essentially, they needed to change their core argument. They wanted to add these things called affirmative defenses of fraud. Now, for maybe folks less familiar, what exactly is an affirmative defense and why do you need a judge's permission? Good question. So, affirmative defense is basically the defendant saying, okay, even if everything the plaintiff says happened is true, we have this other separate legal reason why we shouldn't be held liable. And in this case, that reason is fraud. Now, you can't just drop that in whenever you want. You have to ask the court for permission leave to amend, it's called. In New York, it's governed by CPLR 3025B.
Right, the procedural rule. And the first judge, Justice Kotler down in the Supreme Court in New York County, said yes. And then the Appellate Division agreed. But what's the actual standard the judge uses? Is it like a really high hurdle?
Actually, no. It's surprisingly generous, and that's kind of by design. The system generally wants cases decided on the merits, not on technicalities. So the court will allow the change unless the new defense is, and this is the key phrase, palpably insufficient or clearly devoid of merit.
Okay, palpably insufficient or clearly devoid of merit.
Yeah. Think of it as meaning, unless this new claim is obviously nonsensical or just completely baseless on its face, we should probably let them argue it. Columbia didn't have to prove the fraud at this stage.
Just had to show it wasn't pulled out of thin air.
Exactly. They had to show a good faith, evidence-backed reason to make the accusation.
Okay, so that procedural door swung open. Let's walk through it and see what Columbia actually put on the table, because this is where it gets pretty interesting. These aren't vague claims.
No, not at all. Startlingly specific, actually. The first really big red flag they raised centered on the plaintiff, Juana Taveras, and her daughter. Columbia pointed out that the plaintiff herself had testified under oath. She said she was very close to her daughter, spoke to her, like, every week.
Okay, establishing a baseline, close relationship, regular contact.
Right. But then, when questioned, the plaintiff claimed she knew absolutely nothing about three pretty staggering things involving that same daughter.
The daughter had her own trip and fall accident just 20 days.
20.
Before the plaintiff's accident.
20 days.
The daughter started her own personal injury lawsuit.
Yeah.
Alleging injuries very similar to what the plaintiff was claiming.
Okay, wait. Let me play devil's advocate for a second. Couldn't that just be incredibly bad luck? Two family members, even close ones, having separate, genuine accidents close together. Is that impossible?
Possible?
Yeah.
Maybe. Extremely coincidental, yes. But here's the third piece that really tightened the knot for the court. Both the plaintiff and her daughter were represented by the exact same law firm.
Ah, okay. That's different.
It is. When you layer that, the near-identical timing, the similar injury claims, and the shared legal counsel, the court basically said, okay, Columbia has shown enough here to suggest this might be a coordinated pattern, or at least a deliberate failure to disclose some really important facts.
Yeah, that combination, that feels like the real kicker there. But it didn't stop with just the family connection and the lawyers did it. They also went after the core injury claim itself.
They did,
yeah.
Directly. The plaintiff was claiming serious injuries, cervical spine disc herniations. So serious, she said, they required fusion surgery.
Which is major surgery. And expensive.
Very expensive, yes. A high-stakes claim. But then Columbia brought out the plaintiff's own emergency room records from just a few hours after the alleged fall.
And what did those show?
Well, according to those records, the plaintiff explicitly denied having any neck pain during that initial exam. and she was specifically noted as being negative for neck stiffness.
Okay, that's a pretty stark contradiction. Denying neck pain hours after the fall, then later needing major neck surgery for herniations from that same fall.
Exactly. It's a massive documented discrepancy between the immediate evidence and the later very costly surgical claim.
That contradiction seems huge on its own, but what I find really fascinating is how Columbia brought in something from outside the case, entirely a news report, to kind of build a narrative around why this might have happened. Tell us about the surgeon.
All right, this adds another layer. The defense pointed to a specific news article published June 16, 2024 in the New York Post. And this article reported that the plaintiff's spinal surgeon, the one who recommended the fusion, was already facing public accusations. The allegations were that he performed unnecessary fusion operations on patients, basically for profit.
Wow. So let me get this straight. The Post article doesn't prove the plaintiff's claim was fraudulent.
No, it doesn't prove it directly, but it provides context. It gives Columbia a plausible mechanism for their argument. It suggests an external reason why this specific expensive surgery might have been recommended, even if the initial medical records didn't seem to support such a severe injury.
It helps explain the big contradiction in the medical evidence. Precisely. It gave the defense a potential explanation. Maybe the surgery wasn't driven solely by the accident's impact. So, with all the family connections, the same lawyer, the medical record contradictions, the surgeon context, Columbia clearly felt they had enough for a standard fraud claim, misrepresenting facts in the lawsuit. But they didn't stop there. They went for something much heavier. Fraud on the court. What's the difference? Why is that term so much more serious?
It really is a much more serious charge. Standard litigation fraud might be about, say, faking a document or lying about a specific fact. Fraud on the court, though, is about attacking the entire system. It alleges a willful intent to basically sabotage the whole legal process. The court itself defined it, pulling from other cases. It involves, quote, willful conduct that is deceitful and obstructionist, which injects misrepresentations and false information into the judicial process so serious that it undermines the integrity of the proceeding.
Undermines the integrity of the proceeding. That's the core.
That's the core. It's saying that this isn't just about misleading the other side. It's about misleading the judge, the jury, the whole system.
So by connecting the dots, the alleged false testimony about her daughter, the denial of neck pain versus the later surgery claim, the Appellate Division essentially agreed that Columbia had shown enough to suggest the plaintiff might have willfully engaged in deceitful and obstructionist conduct. It wasn't just questioning the facts anymore, it was questioning her fundamental honesty within the court process.
Exactly right. The pattern of evidence presented suggested, at least potentially, a scheme so deliberate that, if proven true, it would amount to an assault on the judicial system itself. And that meets the very high bar for alleging fraud on the court.
Okay. Now, the plaintiff's lawyers, they obviously fought back against letting Columbia add these defenses. What was their main argument?
Their main counter was procedural. They argued Columbia waited too long. They claimed excessive delay in asking to amend the answer, and that this delay caused prejudice, basically, harm to the plaintiff's ability to prepare her case.
And that sounds like a reasonable argument on the surface. Delay can definitely hurt.
It can, absolutely. But it didn't work here. The court acknowledged the timeline. The deposition was about 6 months before the motion. The Post article about a month before. But crucially, the court pointed out that the note of issue hadn't been filed yet.
The note of issue. Explain that again. Quickly.
Sure. In New York practice, filing the note of issue basically signals that discovery, the evidence-gathering phase is over, and the case is ready for trial. Since it hadn't been filed, the court said, look, discovery is still open. The plaintiff still has time to gather evidence, depose witnesses, and prepare a defense against these fraud allegations.
No trial date looming. You've still got time. No real prejudice here.
Pretty much. No harm, no foul on the delay argument.
And the plaintiff tried a couple of other legal arguments too, right? Something about the defense being premature and Noor Pennington. But the court didn't even really consider those.
That's right. And this is a quick but important lesson in how appeals work. The court basically shut those down immediately. Why? Because the plaintiff hadn't made those specific arguments to the first judge, Justice Kotler. They were raised for the first time only after they lost and went up to the Appellate Division. The rule generally is, you can't bring up brand new arguments on appeal. The appeals court is there to review what the trial court did, not to hear things for the first time.
Got it. You snooze, you lose, procedurally speaking.
Essentially, yes. They cited another case, Ramirez v. Alma, just to show this is standard practice. Arguments not raised below are not properly before this court.
So the bottom line impact of this ruling is pretty stark then. Columbia officially gets the green light. They can now formally argue that this entire case might be built on intentional fraud, including that really serious fraud on the court charge. And all of this now goes back down to the trial court to be sorted out, presumably alongside the original trip and fall claim.
That's exactly where it stands. The fraud allegations are now formally part of the case.
Okay, let's wrap this up. What are the key takeaways for you, the listener, from this deep dive? If you remember anything, maybe remember those specific red flags that opened the door for this fraud defense.
Similar accidents, close together, same lawyer, the huge contradiction. Denying neck pain right after the fall versus needing major surgery later, and bringing in outside context, like that surgeon controversy, to build a narrative.
This case really shows how specific and connected the evidence needs to be before a defendant can credibly yell fraud, especially fraud on the court.
Yeah, and connecting it to the bigger picture, I think this ruling is a strong reminder about protecting the integrity of the legal process itself. Courts need concrete facts, not just suspicions, to fight back against potential dishonesty. It's not just about winning arguments. It's about putting together the pieces, medical records, testimony, timelines, even public info like news articles to show the court when the process might be getting deliberately undermined.
Okay, before we go, here's a provocative thought for you to maybe mull over today. How does bringing in external non-courtroom stuff, like that New York Post article about the surgeon, actually influence these kinds of cases? Does it genuinely help uncover the truth by adding necessary context? Or does it maybe risk introducing bias, stuff that isn't strictly legal evidence, into the courtroom? Really think about that increasing role of public information, media reports, in what are supposed to be private legal disputes.
That's a great point to consider. Definitely something to think about.
All right, that wraps up this deep dive. We'll be back next time to explore more layers of the legal world.